In the last episode, we looked at one of the ways in which the law deals with whether data should or shouldn't be kept out of the public gaze. We found that generally it is possible for parties in a contract situation to achieve that. This episode looks at a potential exception in the field of consumer data.
From a contractual point of view, there are often terms and conditions which have some rules about what you can and can't say or do on a party's websites. So it's common in the terms and conditions to have a provision that people won't use the site to cause damage to the seller. They've been called no disparagement clauses. Often it's for very good motive, so it's not for any bad purpose. It's to say that when consumers or users use a party site, that they'll do so in a way that's appropriate. So that's the intent. Sometimes sellers go beyond that in their terms because they have a lot of commercial exposure to comment that might be guarded or unguarded, but it has a great potential to very much tarnish the reputation of the seller. The difficulty comes up with consumer law because under Australian consumer laws we have something called unfair contract terms, and the unfair contract terms provisions are directed to standard term contracts. The policy behind the law is where there is no real ability for consumers to negotiate the terms. In certain situations, the law can step in and render the terms unenforceable. For these unfair contract terms laws to apply, generally three elements are required. Firstly, the terms in question have to be seen to be causing significant imbalance between the parties' positions. Secondly, the clause is something that is not reasonably necessary to protect the seller's legitimate interests. And thirdly, the clause would cause some detriment to the user. So they're the three elements that need to be established. In the area of standard form contracts, the era of total freedom to contract is out the door. If you have standard form terms and conditions, review them. Are they balanced? Because imbalance, obligations on one but not the other, start to raise the bar in terms of a review. How fair are they? Even language that has proper motive or is intended to capture some problem may be too wide in its scope. So have a look at the width of the language.